Well, hello, everybody. Thank you for joining us for our first of 7 webinars in this series, the 2026 Protecting Your Employee Assets, the Life Cycle, the Employment Relationship. Excuse me. Today's webinar is Welcome to the Team, Recruiting and Hiring, including Restrictive Covenants. As always, I'm Chuck Krugel, the moderator. I'm an attorney in Chicago. This webinar is part of the financial, well, I already said all that. Check out the PowerPoint. We will be discussing it at some points. We don't lecture off of it. If you check out slide number 5, that's our disclaimer. That's a reminder that we're not your attorneys, you're not our clients, and you should not be going out and making important business decisions based on this webinar. This is purely informational, help educate and guide you. Our panelists this year, returning, we have 2 panelists, Max Barak, partner at the Garfinkel Law Group, and Helen Block, law offices of Helen Block, and new to the panel this year, but not, her firm isn't new to the panel, is Katie Rinkus, who's a partner with the Prince Law Firm. And we appreciate you spending your time and money to attend this and not to learn more about us. But if you want to, you can check out slides 35 to 38 of the PowerPoint. That'll have our brief bios on there. If you're pretending to live premiere of this webinar, you can submit questions through the web portal. We'll be watching that and monitoring it. If you're watching this on demand or have any questions after the webinar, you could send an email to info@financialemployees.com. Just include the question, obviously, and the name of the webinar episode, and we'll do our best to get you an answer ASAP. Thanks to our sponsors, the National Law Review. They're on slides 3 and 39, and also Type to Learn and Max X Asset. They're both on slides 4 and 40. So with all that out of the way, let's start the Q&A for this year. Max, over the past few years, we've seen a complete change, really a 180-degree change in how states, the legislatures and courts view employment agreements, particularly pre and post employment restrictions like non-competes, non-solicitations, confidentiality, those types of agreements. They seem to have lost favor with law enforcement. What's your take on this, and where do you think we're headed?
It's funny, Chuck, you gave the one guy here who never reviews non-competes the non-compete question. Thank you very much. That was a good
Sorry,
challenge to start things off. Um,
I like to
you
mix things up.
know, why make it easy on me?
Yeah.
I think what we're generally seeing and nationwide, with some limited exceptions, is a trend pushing back against restrictive covenants generally. When I began practicing, I didn't do a lot of that sort of work, but my understanding was always, these tests are kind of fluid. The test may vary even within the same state, depending on what circuit or district you're in. Um, Katie's colleague and our former panelist, Amit, used to describe for me there was a particular case that was authoritative on non-competes where, like, for the outside of Illinois folks, Cook County is where Chicago is, and then there's the rest of the state. If he was in DuPage County, Will County, Kane County, how that same case was going to get interpreted or whether somebody would acknowledge it didn't necessarily, it wasn't uniform, right? Like, judges had a lot of leeway and it was sort of the Wild West. I think what we're seeing is there's been a sustained understanding that what restrictive covenants often do, with some very obvious exceptions, is not so much protect trade secrets as it is limit worker mobility. So
Yeah.
it limits people's ability to move industry to industry. I think probably all of us on this call are familiar with examples where people, particularly in like the sales or financial services industries, will have a lot of trouble moving firm to firm because there's concerns about them taking clients, or somebody just wants to jam them up and doesn't want them going to a competitor. And it's not about, their products or their services are necessarily different, or, you're going from Coke, taking the Coke formula and going to Pepsi. It's like, hey, you sell the same thing or do the same thing we do here. We just don't want you going across town and backstabbing us or feeling backstabbed. So I think, the trend that regulators and courts are starting to become more skeptical generally as state legislatures keep pushing in that direction, away from enforceability of these restrictive covenants, is the trend. So in some states like California, there's been a general ban or a per se ban on restrictive covenants
Yeah.
or competes for some time. But what we're also seeing, and I'm speaking in generalities, is states either making them very difficult to implement in certain industries, like types of healthcare or mental health, um, or creating much more clear guidelines as to what's going to be acceptable and what's not, making more clear delineations about time, territory, and scope limitations, the consideration or what you are paying or being paid for agreeing to it is becoming more concrete, though my understanding is that's still not necessarily uniform in a lot of places, and it tends to still be case by case. Is
So,
this, hey, the agreement says there's $1 of consideration for a non-compete versus, hey, of this $10,000 is allocated for A, B, or C. So I think that's the general trend, but they're not dead yet, and there are still circumstances
yeah,
where some sort of restrictive covenant is still called for. I gave the Coke Pepsi example, but that's an easy one. Like, you've got some trade secret that's there, so some form of a restrictive covenant that like an NDA or some trade secret protections that limit your ability to disclose that or have access to that information is still workable in most places.
great. Thanks, Max. Helen, let's look at this from a different, in a different context. Let's say, for example, you're in the hiring process and a candidate discloses to you the existence of restrictive covenants during their interview. If you're the employer, how do you proceed?
Well, bouncing off of Max, and I do regularly review restrictive covenants, including non-competes, non-solicitations, et cetera. One of the things that I'm going to do is, Max mentioned, is let's see what jurisdiction applies. Because depending on the jurisdiction that's going to apply to the respective restrictive covenant, it might be enforceable, it might not be enforceable, or maybe some variation between. Like maybe part of it is enforceable and not the entire scope of the non-compete the way it is written. So as an employer who's potentially hiring someone that I'm aware of has a restrictive covenant with a prior employer, I'm going to want to see it. I'm going to want to ask that person for a copy of that agreement. And then I'm going to want to run it by my legal counsel. Now, I would only want to do this if I'm seriously considering the candidate. Now, sometimes when the potential candidate describes the scope of their non-compete or their non-solicit, and I already know at the outset that, gee, the position for which I want to hire them, there's a good chance they cannot work in that position meaningfully for a year. That might be the end of it right there. Because especially if the company from which they're coming from, the former employer, is, notoriously litigious. I mean, that could be a reason. I had someone who, because I do work on both sides, both for, executives and also businesses. I had someone who contacted me who is, in their 50s. They work in a niche kind of industry, and they would like to work for a different employer. And these other various potential employers said, look, we're familiar with your company. Your company sues in this context. We don't want to face potential litigation. We need you to quit, stay out of a market first before we would even consider, you know, interviewing you. So that's why if you do know of someone who has a restrictive covenant, you do want to take it seriously. You want to have the business's own legal department take a look at it if you're seriously considering the candidate. And if this candidate is not worth it, you might want to move on.
Great, thank you. Katie, let's take a step back and focus on another area of risk in the pre-employment process. What are the biggest or costliest areas of exposure for employers during the pre-hiring phase relative to these agreements?
Sure. Yeah, I mean, I think as was kind of touched on already, just a lack of due diligence. Oftentimes, I represent mostly employers, so management side, and I have clients call me that are, they're really excited about a candidate and about an applicant, and they say, oh, they've already signed the offer letter, and I gave them their employment agreement, and then I start asking some questions like, are there concerns that this employee might or have obligations to a former employer? And they're like, no, don't worry about it. But then that actually is a concern, and they're kind of already too far in. So I think, taking a step back at first and doing that due diligence into the candidate. I know we're going to be talking about background checks in a minute in depth, but that's part of it as well, right? Especially if, I also have clients who kind of like are in all different areas. And so, you might want to do background checks, you want to do reference checks, and certainly checking if that they're under any type of obligations with restrictive covenants. I will also say, this might seem obvious, but making sure that if you're hiring someone, maybe if you're a business located in Illinois and all your employees are in Illinois and you're hiring someone in Wisconsin, you're like, look, that's only an hour away. What's the harm? Well, if you don't know about the laws in Wisconsin,
Okay.
if you're not registered in Wisconsin, like if your business entity isn't registered in Wisconsin, that's going to be a delay in you being able to employ this person. I can tell you so many times that I've had clients who, want to hire all these people, and then I kind of outline the costs about having to maybe register in those states and be aware of the laws, especially if you're in a more employee-friendly state. So I think just obviously being aware of what it means for your business to expand like that, and then just obviously making sure you know what obligations those employees are under, and just kind of like doing that due diligence up front.
Yeah, whenever an employer tells me, nah, don't worry about that, it always gives me pause.
It makes me worry about it. Yeah.
Yeah. Um, so Max, let's move on to another area of this, social media. This has been hot for a number of years now, and then we'll also get into AI though too. But in terms of like background checking and sourcing candidates, using social media, what are some of the laws encountered and who ends up enforcing these?
So I I think, you got to think about this in a few different ways. I think, it's funny when I started practicing and giving talks like this, the notions of social media and how it plays into the law and litigation felt, I think, a lot more esoteric, and the types of people coming, it sort of looked like everybody felt panicked at those webinars or CLEs. It's like, oh my God, I don't understand what any of this tech lingo or this is. What's a Facebook? What are these things? And now, my memory is most adults have some form of social media and some sort of understanding of what we're talking about. Whether they understand that anything you put on the internet sort of lives there and there's no, well, that's my private, this, that, or the other is sort of a separate animal. But I think generally speaking, my own experience anecdotally is it's more understood that these things are visible. People can see this stuff and it can have consequences. I think more broadly, it's now within that framework, it is fully normalized in recruiting and background screening, but it can create risks, right? So, like, it can be used for LinkedIn purposes. LinkedIn's pretty common, right? I just saw a commercial for their AI like job search product, which is a
Oh
little
yeah.
wild during some football game I was watching. But also for screening, right? Like, what are people doing in their free time? What sorts of things are they saying on the internet? You know, I think, as with a lot of pre-hiring inquiries or dangers for employers, think about the different laws that can be implicated at any stage of it. You have the various state and federal anti-discrimination laws. Title VII, the Americans with Disabilities Act, Age Discrimination and Employment Act, any state equivalent that covers that. You know, you could have candidates whose names maybe don't give away what their background, ethnicity, skin color, race, religion, what have you are. They get a job offer, their social media gets looked at, and suddenly it gets yanked. Failure to hire cases are really difficult to prove, but you never know what's going to happen. You never know what'll come out of the woodwork. And by the same token, if you aren't checking for some things, like you and Katie alluded to, you always want to do your diligence on the front end because there may be stuff, screaming red lights that are very public and visible that you're just ignoring. Some states, like our state, Illinois, have social media privacy laws of sorts. Um, they can at times run into the at-will employment doctrine, right? But in Illinois, for example, we have the Right to Privacy in the Workplace Act, which, although being a little bit toothless in terms of penalties and causes of action, does, for example, prohibit employers from, I think, firing or discriminating against folks for lawful use of products in their free time, which I think originally was written by the tobacco lobby. But I could be off on that, but that's my understanding that you can't fire people for smoking except like if you run the American Heart Association or what have you, or Jump Rope for Life or one of those, their heart, whatever it is, one of those types of places. But I've seen it expanded in some ways to look at social media as well within some of it. And then, you have the Fair Credit Reporting Act, right? So if a third party does social media background checks, there is the potential that disclosure and consent requirements can be implicated and pre-adverse action notices are required. If it leads to a discrimination claim, you may find yourself staring down the barrel of an EEOC charge or investigation, though I suspect these days that's less likely unless it's anti-American or whatever discrimination they call it at the EEOC right now, and what have you. So I think, you know, there's different ways this can get affected. I think you just always want to be mindful, like my always refrain here, right, is check with your employment counsel, make sure you're up to speed on what your state laws are on this, and if you're running afoul of those laws or any other federal law by how you're using it.
So just I'll throw this out to everybody on the panel. What about AI? We're starting to see now increased regulation of the use of AI, especially for for pre-employment hiring.
Well, I think you really have to be careful with that as well. And that is an area where you can see federal discrimination. I mean, there's sort of this patchwork of state laws that are starting to slowly come into effect, state by state, with rules about how AI can be responsibly used or not being limited at all. But there have already been lawsuits that are on record about this topic. So, for example, the iTutor case, it's a couple years old now. It was 23 or
Yeah.
24, I think. But basically, a Chinese tutoring company that was hiring American workers to do, I think, tutoring or translating into English, had set up the screening on the AI software such that if your age was, let's say, men over 55 and women over 50, or like your name sounded vaguely ethnic in a certain way, you were not getting through the screening. But like a Fair Housing Act case, somebody changed some of their criteria and applied and got through. So that ended up in an EEOC investigation, a lawsuit, and an expensive consent decree that in part they're not even doing business in the US anymore. So, you know, there are definitely risks to it, and AI can be useful, but I think as with everything else, you shouldn't treat these things as a panacea. You could also, I could see an ADA issue. So there's already a lot of website lawsuits that get filed, I know, which a lot of folks can think are pretty frivolous. I'm not taking a position on it. They're a
Yeah.
thing. But, you know, if, for example, you have facial recognition software that you're using and somebody has a stroke or some other disability that makes their face operate in a certain way that might have the effect of harming them, you could be getting your company into danger there. So I think, you know, as with everything else, make sure it's not garbage in, garbage out. You're being thoughtful about why and how you're using things, and you're making yourself aware about what sorts of notice or disclosure requirements exist, you know, at the state and federal level.
I was going to bring
Anyone
this
else?
up in
Go.
my answer actually, but I figured we would talk about it later. But I do think that's increasingly becoming a greater risk in pre-employment decision. I mean, it is becoming a greater risk because states are coming out with these laws, not banning it, but being like, be like very careful using it, right? Because it could be a violation of civil rights laws. And there are so many AI tools out there for recruiting, especially for large companies that are like inundated with applications and they don't have the manpower to go through every application. They're using these softwares to just sort through the application and they put in keywords and stuff. And so that I think that's just it's just a very easy way to get yourself in trouble. So I think as it continues to grow, there's new tools available. I'm telling my clients just to make sure that like you're really reviewing those agreements to for liability language, and it'll be interesting to see where it goes. But I do think that's going to be a big area where employers are going to see increased exposure.
Well, and
Yeah, on top of that, um,
go ahead,
I
Helen.
don't know if, I was going to say there are states with, I think Illinois being one of the first, to actually pass legislation that if you are going to use AI in employment, which isn't really defined yet because the law is so new, I mean, it literally just went into effect, you have to let your employees know or potential employees know how you are using AI or using AI in the workplace. And then the question becomes, I don't even know what AI is today. Because in the past, when you would just type something in the internet and you think you're Googling something, today it pops up that AI, you're using AI. So I don't even know what the scope of these disclosures are going to be. And we're waiting to see how states are going to interpret what constitutes AI and in what context you need to disclose that you're using AI in the employment context. And it seems the way we're seeing some of these laws being passed, it is broader than just in the hiring process. It's in the employment context. And so no one really knows what the scope of that is yet. So be very mindful.
Well, and the other thing I was going to say is I sort of assume that a good chunk of the time I talk to clients now, I'm getting AI. Like I can tell I'm not like a genius or anything. We've as a firm used AI products enough where you can start to spot things, but like it's pretty clear when I ask a client for something and I get, as the kids say, like AI slop or a chat GPT generated like analysis of their case, which is meant to convince me that this is the crime of the century and I ought to
Yeah.
jump in. And I think that applies to employers too. The people need to remember a lot of these AI products are designed to placate you or please you. Like that is their directive to, in theory, give you good information, but that's not always true. So A, the information can be not credible. And B, it's sort of like WebMD with doctors or people surreptitiously recording you. Like, I just assume half of what I do now is going to end up getting fed into some AI that's going to tell somebody what they want to hear. So I'm not saying you ought to make employment decisions on that, but just, another one of those things to kind of keep in mind, as you go along, that might be going on in the background too, and be conscientious about how you handle these situations.
I think employers need to understand the learning models or the language models that these AI platforms are built on. Like you said, garbage in, garbage out. If the data model set that they're using is garbage, then you're going to end up making terrible decisions. Thanks, everybody. So, Helen, move on to salary history. That's also been banned now in a lot of states, even though historically, for decades or since the founding of America, it's been perfunctory to ask people about their salary employees or prospective employees about their histories. What's going on with that now? Why is this happening?
Yeah, you're right on the mark. I remember, years ago when I was hiring myself for, paralegals, I would have folks come in with resumes. I didn't even ask for it. And it would list right on their resume what their prior salary history was at different jobs that they had. And I didn't even ask for it. It was so common. Today, in most states around the country, you cannot ask someone um, what their salary is at the jobs. And I know this drives folks in the finance world absolutely crazy because there are certain industries in which an individual's compensation essentially um, tells the potential employer at what level they are performing and what their position should be within the company. So there are some, potential employers who find this to be very challenging, but that is the case. You cannot ask someone what they were earning previously, and even to take it a step farther, it's now becoming common in a lot of jurisdictions that when an employer posts for a job, they have to include the salary range of what they are going to pay the potential employees. Now, what you still can do, and which is perfectly legitimate, is you can say to a potential candidate, um, "This is what we are willing to pay." Be upfront about it, and then it's up to the candidate whether they want to accept or not, or to negotiate. And that's where we see, in fact, the law is taking us anyway because they're requiring employers to post. So, I always say, and I've even said this before the law mandated it, you know, don't waste your time. Put it out there what the range is for the salary. Why are you wasting your time in interviewing folks and for them applying and spending the time with the cover letters and the resumes or whatever people do today? If the parties are going to be so far apart anyway in terms of what is thought of in terms of the position. So now, in a way, that's kind of becoming the norm, which is we cannot exactly ask what we can't ask, not exactly we can't ask in general in most jurisdictions what a person earned. And in lots of jurisdictions, we're being required to post what we're willing to pay someone for a potential position. So I would say just be upfront about it and let folks know what the salary range is going to be.
Thanks. Uh, Katie, let's move on. Let's kind of stay in this area, like the restrictions, but in a different context, criminal convictions. So increasingly, employers cannot ask about convictions on the application and must wait until they make a conditional offer or select that prospect for an interview. What is a conditional offer? Can you give some examples of that?
Right. So Like it sounds, a conditional offer is an offer of employment that's conditioned on the results of a background or a reference check. Um, always recommend that this is included in an offer letter. So if you decide that you want to make an offer of employment to a candidate, you send an offer letter, and in the offer letter, it should say this offer is contingent on, successful completion of a background check. At that point, then the employer can and should go through their background check protocols. But I think as Max referenced earlier, the Fair Credit Reporting Act has very strict requirements regarding disclosures, notices, and rights that people have under, like, if an employer is performing a background check. And I obviously, advise clients to use like reputable background check companies because the Fair Credit Reporting Act has such stringent requirements that you want to make sure that those companies are providing the required notices and disclosures. And the reason for all this is because most states have what are called ban the box laws now. So Illinois has it, California, Colorado, DC. Connecticut, Georgia, Massachusetts, New Jersey, among others. And also, other jurisdictions, like local jurisdictions, have even more specific and oftentimes more restrictive laws. So, New York City, LA. So, again, this is why it's very important that employers understand where the applicant is located. Because if you're in Chicago, you're hiring someone in LA, even though Chicago has Illinois has a pretty strict ban the box law and requirements that you have to go through. LA is likely stricter. I know this because I just had a client issue with it. Um, and so essentially what this means is, like, once you give someone an offer, you run a background check. What happens if on the background check there's something that comes up that might that as an employer gives you pause and you want to either rescind the offer or at least ask more questions, right? Um, you can't ask directly about criminal history or convictions on an application. You can only get it through the background check. So if the check does reveal a criminal history, employers do have to take very specific steps after that and cannot just automatically revoke an offer and say, okay, you can't work for us because of this history. Um, there's very specific steps you have to take, and I would certainly advise, consult with counsel about this. But essentially, at this point, state laws and the Fair Credit Reporting Act require that you engage in the pre-adverse action notice and disclosure. And basically, this just means that you have to provide notice to the applicant that something arose on their background check, and then give them the opportunity to respond or provide some detail or maybe even dispute what was on the background check. After that, an employer can rescind the offer, but they do have to go through those steps to make sure that they're not violating these laws.
And by the way, the box you referred to, that's the job application
That's the
question.
job, like you can't have a box on your application
Yeah.
saying, were you ever convicted of a felony, right?
Yeah. And by the way, just adding on arrests, they're like verboten, right? You can't, nobody, I don't think there's any state when you can ask about arrests.
Like if you have ever been arrested
Yeah.
for anything, um, I believe that's true. Yeah. I mean, usually it's only convictions, right? And it depends on what type of conviction too. It's usually like a felony conviction, but um, so that's right. Yeah.
Yeah. Generally felony. Yeah. Um, so, all right, Max, regarding like these criminal background checks and the inquiries, what do you do if an applicant discloses a conviction? How should the employer proceed in that situation?
So don't panic.
Yeah.
And don't improvise. Don't do anything you might regret right away. Pause and call Katie or Helen if you're in Illinois, because they're well versed on navigating these things. But no, make sure if you're doing these sorts of background checks, you do have that robust policy that's written down and you've explained what's going to happen, and follow it. And you need to apply it consistently across candidates for the same role. So if you're doing the background check, you should have an individualized job-related assessment. Contemplate things like nature and gravity of the offense. Is this, hey, you picked up I don't know, like a drinking ticket when you were 18, you're now in your 30s, have all these advanced degrees. This shouldn't disqualify you from like Argonne Labs kind of thing? Or is this, hey, you have sex offense in your history and you want to be working a school, and perhaps these are not a good fit, right? You need to know, how much time has passed. How does it apply to the nature of the job? Is the conviction a specific risk relevant to the job or the role you're hiring for? Is a big factor. And then mitigating evidence, right? Like, is this an ugly conviction, but is this person in their 60s, lived a clean life since then, and this is a mistake they made when they were 18 versus, yeah, they're out 6 months and, you know, nothing has really changed here. Um, you need to be documenting, as with a lot of areas we'll talk about on these webinars. Your rationale needs to be documented because the job requires X skill, risk, liability, what have you. And the conviction involved Y behavior and occurred within Z years. We are making a B or C decision, or we have reached this inquiry. Try to avoid the auto disqualifiers. I think that's where you see a lot of the disparate impact litigation. So, not, oh, you are making choices because of somebody's protected category, but this facially neutral policy, or this policy that looks neutral on its face, has the effect or impact of discriminating against this class of people. So, like, because I am screening for X conviction, and in this jurisdiction, this particular race, gender, age group, what have you, has a high conviction rate for this crime, by creating this rule that has no connection to my job, I am effectively screening out people of this protected category from working at my company, kind of thing.
Same
So you want to
thing.
avoid outcomes like that.
Same thing with the AI that you just discussed,
Yes.
that, like AI having, you think it's like facially neutral, and then it has this effect, or in the worst case, or one of the worst case scenarios, the effect of, disparately impacting or disparately treating certain protected classes to the extent that they're excluded from hiring.
Right. And so, I mean, I think, there's no uniform takeaway, right? And the
Yeah.
state and federal requirements here differ a bit, and every state's got different, restrictions to the extent they have any. But I think if you were looking for an overall rule, is that, convictions aren't a free pass to reject a group or individual. What matters, if you're doing these sorts of checks, is whether the conviction is job related and whether the exclusions you're implementing are consistent with a business necessity. And that you have an individualized documented review that you can stand on and you're willing to commit to.
And interactive discussion. I mean, that's a
Uh-huh.
big part of this too now, that like with the ADA or Family Medical Leave Act, that you have to engage the prospect on, or if they're already hired, the employee in an interactive discussion as to, the circumstances.
Right. And
Can
I
I
mean,
also say, oh, I'm sorry, I didn't mean
no,
to.
no, 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 no,
This
no.
is your
Go ahead.
question, Max. I don't.
Doesn't,
No,
my God, buy in
I
shame.
just, I just wanted to say that I have had scenarios where like the background check is wrong, and
Yeah.
it actually happens pretty, like, it's kind of scary how often it happens. But like, for example, it will list something that was supposed to be expunged, and there's a reason it wasn't expungible. It's because it happened, something was, uh, when they were, what, for whatever reason, I'm not a criminal attorney, so I can't speak to that. But like, if it shows up, that obviously can have a real impact on people. And so the ability for that person to be able to discuss that and like provide some context, that's the whole reason why these laws are in place. So, as an employer, I think you have to keep that in mind instead of just seeing like a potential issue and saying, oh my gosh, this person's a criminal. So I just wanted to note that.
Well, and I've seen a couple of these. I haven't handled them myself, but one of my colleagues at our firm has handled a couple of these conviction history cases, and they seem to drive employers crazy. At least the Illinois law has. The ones that we've handled through the Department of Human Rights, our state anti-discrimination agency, because they feel like footfalls, right, or these quote unquote technical violations. Like, well, I don't get it. If we just followed steps A and B a little more carefully, or done this, we still could have screened this person out of the job. Why are we supposed
Just
to do?
you just froze up for a couple seconds.
Oh, that's not good. Did you hear what I said, or am I
You're
just talking
You,
back
to
now.
myself?
yeah, you kind of cut off something about what they were supposed to do uh, after they get the results of the check, or yeah, negative. It went after they get the results of
That's,
a hit.
it's weird because I'm seeing all my bars, but I'm being told my internet connection's unstable. I guess better than me being unstable. But
Yeah.
what I was saying was, was just that the cases my firm has handled like these are frustrating for the employers, and I've had the agency employees tell me the same thing, which is employers are going nuts over this because in theory, you can be liable for discrimination for screening somebody out of a job who you ultimately could have screened out had you simply followed the interactive steps correctly. But if you skip a step, you're lining yourself up to get a charge filed, even or a claim brought, even if ultimately it didn't have to change the outcome, because you need to at least give people that step.
We
So just, be mindful of you can still screen them out. You just need to follow the steps that the laws require if it is truly related to the job and something you want to watch for.
just
Here's
days
the
ago,
kicker, though. Oh, sorry, go on,
just
Chuck.
yeah, just days ago, I negotiated a settlement during mediation of an exact claim like that, where basically my client failed to inform the employee of the hit that came back on the background check, and they failed to engage in an interactive discussion, even though they had another legitimate reason for excluding that candidate, meaning what it's called under law, mixed motive. That yeah,
Right.
they're part of one aspect of the motive, let's say X was illegitimate, and then Y was an aspect that was legitimate. And so, it was a difficult negotiation, mediation, because the employee who blew the whistle on them, or the prospective employee, was right in one regard, but in the other regard, we had palpable defenses against their claim. So, sorry, Helen. Go ahead.
No, I was just about to say, though, here's where sometimes the line gets blurred. What if you did not find out the information from a background check, but from the newspaper? So, for instance,
Yeah.
um, it's against the law to use criminal arrest records, et cetera, in employment decisions. Well, what if it just so happens that your potential candidate or whatever the case may be is splattered on the news that they were arrested or was in the newspaper or whatever the case may be? The potential employers could argue and could successfully argue, we don't want it to have that image. That's bad for business. So it has nothing to do with the fact that the person was arrested, but the information that's out there in the public domain would be bad for our company. Like we would not want our customers, are those with whom we're doing business, et cetera, to think that we are, let's say hiring someone, who's a sex offender, or hiring someone who, for instance, has certain viewpoints, or and that's unfortunately where the problem in reality does come into play.
So I want to let's kind of tie this back to what Katie said a minute ago, though, about a lot. Sometimes these I don't know what percentage of time, but sometimes these background checking companies come back with bad results. Now, if you get, and this happened to me like years ago, where we were researching a candidate, I was helping a client out, and we researched a candidate, and we found, they found out about conviction, but they couldn't find the nature of conviction. So we searched on Google, and up came an article about this candidate that he was arrested for allegedly molesting kids at a fast food restaurant drive-through. And so we took action based on that. Now, let's say that article is wrong. But if we, in good faith, if we believe it, that's a defensible position. Am I right?
I would say it depends on the position for which you're hiring the person. Are
Yeah.
you,
Okay.
for
Yeah.
example, hiring the person to, let's say, work in a warehouse by himself stacking boxes? Okay. The the instance of that individual, molesting someone if they work kind of all alone, like here are these boxes, go stack them, or here, paint this, paint that, and they don't have to interact with other individuals. It comes back to, I think, either what Katie or Max said about, is it narrowly tailored to the specific job for which you're hiring? Now, that person, though, I would say you would not want to hire in a daycare, because keep in mind, you hire that person in the daycare and they do engage in inappropriate conduct. Well, you were on notice and you've just opened yourself up to a negligent hiring claim.
Or even
So,
just delivering to places like
residences.
schools
Yeah.
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 or,
Anywhere there's kids
airports.
around, like they're,
Yeah,
like near a
exactly.
school or something like that.
Right.
Yeah, great. Thanks. Um, Along those same lines, Helen, um, what were some good indicators of, like, good due diligence, like, effective research on these background checking companies?
Well, what I would say is that, as Max and Katie talked about, there are very specific things in different states that one needs to do when they're performing a background check, like for instance, under the Fair Credit Reporting Act, or perhaps, other states have requirements about disclosures and consents that the employee has to sign in order for a background check to be conducted. So if you're going to use a third party company, ask to see a copy of their paperwork. What is the paperwork that they provide? Make sure that they actually do provide the required disclosures before providing the background checks. Ask what their process is. What happens if there's something that negative comes about? What do you do? How do you disclose it? Do you tell the potential employee? Do we tell the potential employee? Who gives them the opportunity to respond? And so I would vet all of this out with a potential company that you're considering hiring to ensure that they are conducting their checks in compliance with the laws of the jurisdiction that apply to the business and where the individual will be working.
Good, thanks. Uh, Katie, should employers screen or conduct these background checks on all employees, or can they do it only on certain employees? Can it be like a ratio of like one, maybe one quarter or 25% of the workforce?
I think if they're going to do it on anyone, they have to do it on everyone. If you pick and choose, even if it's, you're not being like intentionally discriminatory about, it, I think it can easily veer into that sphere pretty easily. Um, So I think especially if you're in and also this goes without saying probably, but in certain industries like daycare workers and people who work with kids like physical therapists and stuff, I think they are like the employers are required to do certain background checks. So like then you have to do it. But yeah, I just think if you're gonna you should have the same process for every employee. Um, that's like an easy way. That's like an easy way just to make sure that you're being compliant.
Great, thanks. Changing gears a little bit here. Max, job descriptions. Are these important for hiring and recruiting the right people? And if so, why?
Didn't think of anything silly or clever, so I'll just say yes, they are.
Great,
I think this matters for legal and non-legal reasons, right? Because at the end of the day, whatever the reason you're listening to this webinar, whether you're a general counsel type or somebody who represents employers and just brushing up on what's new in employment law that you need to be aware of, or you're a business owner or otherwise, like at the end of the day, you want the business to run smoothly. And I say this as a plaintiff's employment lawyer and an employer also. At the end of the day, you want people to know what is expected of them, what are they hiring for, and all of it. You want them to succeed. It's always cheaper to keep somebody and fix them, assuming they're not, a major liability or problem for your employer, than firing and hiring somebody new. At least that's my understanding. And a job description is really one of the first parts to that, right? So, thinking about, well, is the background check relevant to the job? Well, you got to step back even further, right? Like, what are you hiring for here? Like, what is this job? Um, are you a startup? Are you still in that phase of everybody does everything? A job for that looks a lot different than a small, well-established, or even a big, well-established company. I think they matter because from a non-legal perspective, it's hard to expect somebody to succeed if they don't know what's expected of them. And they're more likely to succeed with structure and knowing what they're required to do and how and in what way. But from a legal perspective, if you don't have that, the possibilities for somebody like me as a plaintiff's lawyer are really endless if you don't document things. So, a good job description is the backbone of hiring, right? And of defensibility of the hiring and firing and performance decisions you make. If you tell them the job is X, but you require them to do a bunch of other stuff that's unrelated, the gender discrimination example I always think of is somebody, you hire a man and a woman to do the same non-admin job, but like think, they're both analysts in some financial organization, but the woman is the one you're always making get coffee, take notes, act like a secretary in meetings. He gets seniority and is given assignments where she gets secretarial tasks. They have the same job, but if there is no job description, or you're just treating them differently, or there is a job description and you're not following it, the danger is similar to the employer at that point, right? So it can offer you protection. It creates structure in that way. From a disability perspective, you think about the Americans with Disabilities Act, employees get hired and have restrictions and need help to do things. You need a job description that is clear and legitimate and concrete so that you know, can they legitimately do this job? And you talk about the interactive process with conviction history, and it's something we'll deal with in the ADA and FMLA webinar down the road. But if somebody needs help to do their job and they're asking you for help in that job, you need to know, are you even able to do the core job functions? And if you don't have a robust job description that says what those are, that analysis and the defensibility of your positions you take gets harder and harder. Um, and then there's other practical criteria. Like, well, how do you evaluate whether somebody's doing a good job if their job description shifts by the day or isn't well defined?
Right.
So the legal and non-legal implications of not taking this seriously are significant. A good job description, I think all of us have a different definition, but in general, it should have clarity, it should be concrete, it should actually describe what this person is expected to do, and not use vague and ridiculous language that like they're expected to be a rock star who has high energy, and gets it, that kind of thing. Be careful and don't put things in there like they got to be young and hungry and proactively age discriminate. So like, you need to think through it. You want to be serious about it. And you want to think about, what are you asking of this person?
Nice. So, Helen, this is getting off on a little bit of a tangent here, but it's something that's comes up a lot, or I see a lot in hiring and selection, recruitment, all that. It's this idea that a lot of employers want to classify somebody who should ostensibly be an employee, but they want to classify them as a 1099 independent contractor. And, because it avoids payroll taxes and insurance, workers' comp, and all that. What are what are some of the key things you look for when when a business is telling you, hey, we want to hire somebody, but we want to hire them as an independent contractor, not as an employee?
Well, all those things you said, save money on insurance, saves money on taxes, is honestly the opposite. If truly they really should have been an employee, and the only reason why the individual is retaining them as an independent contractor, meaning their own business person, is because they want to save money on taxes and insurance. Because I could tell you right now, if the roost is up and one of these individuals either files an action, or one of the various government agencies that looks at these issues gets wind of it, the employer is going to spend far more money defending themselves in an action than they ever would have spent on paying taxes or paying the insurance. And one of the best examples is workers' compensation, because that's the one that can really bankrupt an employer. Because if you call someone an independent contractor, it's like, a duck. If it looks like a duck and it quacks like a duck, if you call it chicken, it's still a duck. I don't care. Just because it's a bird doesn't mean it's, one type of fowl. If it's one type of fowl as opposed to the other type of a fowl. And, especially in the workers' compensation context, if it turns out that someone really was an employee and misclassified as an independent contractor, you're going to have to pay that person's not only a certain amount of compensation, but their medical bills. And if it was a serious injury, that's the one that can bankrupt the business, because for a lot of states, have have as the law that it's a legal requirement to have workers' compensation insurance. And if you don't have workers' compensation insurance, a corporation is not going to shield you. The person who made that decision, an owner of that business, could be held personally liable. And
You
that's the one
run
that can really, bankrupt employers. And so when
you
you're
run
when
afoul of the law.
yeah, so when asking, classification, can I classify someone as an employer or an independent contractor? The fact that you're asking the question really begs, is this person integral to your business? Are they performing essential job functions that are essential for your business? Or is it ancillary? And here's a perfect example. A plumber, right? Unless you're in the plumbing business, if your sink breaks down, it is not, an integral part of your business to have someone fix your sink. That is an example of someone who rightly would be classified as an independent contractor. So if you're in the marketing business and you have an office and your sink breaks down, Sure, call in that plumber and you don't have to worry about the classification because you're in the marketing business. You're not in the plumbing business. But if you are in the plumbing business and you're sending folks, to, clients' homes to fix their sinks, and you bring in someone who is a plumber to fix a sink, and that is all the work that you do, just plumbing, and you're keeping that person busy every day of the week, and that person cannot do any outside work, good chance you could be dinged for misclassification because that's the exact kind of work that you do. You're asking that individual to perform the kind of services that are integral to your business. And that person really should be your employee and not an independent contractor. So there are a whole set of laws and different analysis as to whether someone is an independent contractor or someone's an employee. Sometimes it is a gray line. Sometimes there are factors that weigh in the favor of one versus the other. And the way courts look at this, and for example, the Department of Labor is like a totality of the circumstances type of situation. So it's not just enough that you pay someone on a 1099. It's not necessarily just enough that you have a written employment agreement. What about control? How much control is being exercised over the individual? Can the individual make decisions with respect to when they're going to perform the services? What tools they're going to use to perform the services? Do they have any strength in negotiating what they are going to be paid for the services? If they're completely under someone's control, then they probably should be that, person's employee and not an independent contractor. And so, and not only that, the other thing you have to look into is if you are going to treat someone as an independent contractor, a lot of states have written requirements as to how to treat an independent contractor. And unless the individual has an entity like a corporation or a limited liability company and you fail to pay, well, they might be able to sue you under the various wage laws, no different than if they were an employee. And that is the trend in a lot of jurisdictions these days.
And tying this into the other part of our webinar today, the restrictive covenants, what about companies who utilize or hire independent contractors and then try to restrict them from working for competitors or divulging secrets or that type of stuff?
So that's really a good question because if someone is truly an independent contractor, they might not fall under the body of case law that regulates restrictive covenants with respect to employees. They might fall outside of it. But again, if they're misclassified, then they're going to be treated like an employee, and that whole set of factors is going to come into play because to the best of my knowledge, there isn't really a law that restricts restrictive covenants when it's a business to business. If
Yeah.
it's truly a business to business and
Well,
it's supported
yeah.
by consideration.
I mean, yeah, but you can maybe restrict them in terms of divulging business secrets or client lists or something like that, but you may not be able to restrict them from working for competitors in other states or, things like
You
that.
got the Sherman Antitrust Act, and the issue
Yeah.
becomes is this, violation of other big laws like, antitrust, if you try to restrict these, even in the business to business context, then you might be looking at it more in terms of antitrust law as opposed to employment
Yeah.
law.
Yeah, exactly. Thanks. Katie, one of the hot topics these days is hiring for culture or fit. What does this mean and how do employers do this and what kind of trouble can they get into? I think Helen just brought up the idea of like saying, or no, Max said it like, we only want the best people or those types of superlatives.
Yeah, everyone loves to talk about culture and how great their culture is. We do culture audits and we see that that's not always the case. But I think, at the interview stage, like you have to ask interview questions to ensure that the candidate aligns with your firm's mission and values. Does your company have a mission statement? Does your company have values? If they don't, like that is kind of step one to figuring out what your culture is, right? Because then you kind of work from there. Um, you know, Consider using like a personality test during interviews. Like there's different, not an IQ test. I'm talking about like
Was that
Enneagram
Myers-Briggs?
yeah, that at our firm we've used a few, but the last one we used was called Colby. And it's really interesting. Like it is interesting to learn about it for yourself. And like it's kind of t talks about like how that person works. It's not really the personality, but it's like how like in what scenarios do they work best and what scenarios do they kind of shut down and and then it'll like compare people and like this person works best with this type of person and it is actually very helpful for workplaces and for culture, but it's good to do that. Our firm does that, and I think it might be kind of annoying for people who interview for us because it is kind of like a long process, but I think like we have that process for a reason because we want to make sure that people fit into our culture. So, making sure that you ask questions that can kind of tell you how they will fit with the mission and values, doing maybe kind of some type of like personality test like that. Again, it has to be applied uniformly, do it for everyone. And then also just, like trust your gut. That's not really a legal thing, but I think if you've interviewed enough people, you kind of will know if this person will fit in, or if they won't. And I think if you've interviewed really enough people, you will know if that person's also potentially a liability. You never know. There's always those kind of unicorn people, but and have multiple people from the company interview too. I don't think it should just be one person talking to them. Multiple, giving different opinions is crucial.
Well, there's no test or assessment that's like totally valid that, works perfectly. I mean, there's always going to be
No,
some margin of error.
yeah,
Uh,
but they are. I think they can be helpful.
oh yeah. I mean, an
Hmm.
ounce of prevention is worth a pound of cure. So, um, I'm going to throw it a couple minutes. I'll throw this out to all of you. What do you do with rejected candidates? I mean, do you notify them of the rejection? Do you keep their records? How long, if yeah, how long do you keep records for? Anybody want to tackle that?
Um, well, it depends, I think on how far along someone got in the interview process. So I think if, let's say, you brought someone in for 3 interviews and it's not a good fit or whatever the case may be, it's common courtesy
Yeah,
to let someone know and to send a letter that, or to call the person or send a letter that, they did not obtain they did not get the job. If, let's say, for instance, they were never even brought in for an interview and it's like, let's say, a lower level type of a position or whatnot, and you didn't even consider their application, I don't necessarily think it is a problem to send a rejection. I mean, in general, it is common courtesy, I would say.
it's
Um,
professional. Yeah.
yeah, but certainly, if you interview someone, I would keep a record of the interview. I would show, so this way you can show uniformity that you ask similar questions to all the various candidates, because later on, a person could allege a failure to hire for discriminatory reasons. And then you have your notes and you can explain why, this person wasn't a good fit for your business or why the person you hired had better credentials. So I do think it is important to keep a record of those with whom you're interviewing and with those with whom you've considered for the job or accepted their application or reviewed their resume.
Anyone else? No. All right. One final question I'll throw out to all of you too. Um, you made an offer over the phone. It was accepted. Do you follow that up with an offer in writing? And so, what do you say in it?
Definitely. There are certain things that certain jurisdictions even require that you put in writing. So, for instance, you should tell someone how, the salary that they're going to receive. You need to let them know how they're going to be paid, weekly, biweekly. You're going to want to explain that, withholdings are going to be deducted from their pay, whether they're exempt, not exempt. If there's certain hours that they're required to work, perhaps you might want to put in the title of the position. You might want to put in certainly that it's not a contract for a definite period of time, unless it truly is, unless there is an employment agreement that this is like, often you see this, let's say in C-suite executives, that they do have actually employment contracts. You see it with doctors often as well, that they have employment, contracts that perhaps have a duration. But unless there's going to be a duration of specific employment, you want to be very clear that the documentation you're giving them is actually not an employment agreement for a specific period of time, that in fact it is at will employment. Going back to something that you asked about earlier, what is it? What is the criteria for the job? Well, one of them is also that they have to be legally eligible to work in the United States, and you might want to put something like that in there. And other job requirements, as Katie mentioned before, that that the offer is contingent upon a background check and reference check. And so these are some of the things that you're going to want to put in an offer letter, generally speaking, across the board.
Any final thoughts from Max, Katie?
Stay on
No.
top of, stay on top of the law. when in doubt, if you can swing it, do the ounce of prevention. It's probably going to save you a fair amount on the back end and give you a much better workplace.
Thanks. So with that said, we're at the beyond the top of the hour. Thanks everybody. Great job. Great presentation. We're going to be back for number 2 in this series of 7, an ounce of prevention, policies, procedures, and proactivity. And that's on February 19th at 2 p.m. Central Time. So look forward to seeing all of you then. Take care, everybody, and stay warm if you're outside, if you're in the Midwest.
Thanks, Chuck.
Bye.
Thank you.
Take care.